Court at Toronto are now open. The Honorable Madam Justice Snyder is presiding. The court calls file number T2007-12, Thahoketoteh of Kanekota and the Minister. Appearing on behalf of the plaintiff on his own behalf is Thahoketoteh, and appearing on behalf of defendant is Mr. McCullough. Can the parties please identify yourselves to the court?
I'm Thahoketoteh of Kanekota. Good morning.
Good morning. I'm Michael McCullough, appearing on behalf of the Attorney General of Canada.
Thank you. And good morning, Mr. McCullough, as well. Mr. McCullough, this is your motion to strike the action. And I notice in your motion that you certainly go into the merits of the action, but I have a preliminary problem with the action, and that is that in the pleadings, there are absolutely no facts pleaded. I have no situation where the Crown has refused to acknowledge the claims of the plaintiff in this matter, and I'm wondering why you did not raise this as your first ground of rejecting the action.
Well, Your Honor, we certainly considered approaching this matter on a number of procedural and jurisdictional issues. However, in discussions with the instructing ministry, the Ministry of Aboriginal Affairs and Northern Development, it was decided that we should approach it directly because this issue keeps on being raised and we keep on dealing with procedurally, but we would like it actually to be decided on the merits because the plaintiff in his Rule 220 motion has made it part of his case that there are no facts needed. And therefore we're prepared to deal with the legal facts, as he calls them, has pled as basis for striking the motion under Rule 221.
So
I entirely agree with you, and we did in fact consider that this is certainly not an appropriate subject for a Rule 220 motion, since there are no agreed upon facts, and indeed, as you pointed out, no facts at all.
Okay, then we have that on the record. There is always a hesitancy, particularly with a subject matter as serious as what is basically a constitutional argument, that the court refrain from making determinations on the merits in the absence of a factual context.
And the Supreme Court has been very clear on that. I didn't include it because we weren't addressing it, but it stated that emphatically in its decision in Kit Kaplan.
Do you have a cite for that?
As I said, we decided not to approach on that matter. I can certainly get it for you in a few minutes.
Okay, well, I'm going to hear you on the other aspects, but I just wanted to alert you that you may not get the decision you want out of me if I determine that there were no facts pleaded, and therefore no valid and no reasonable chance of success, no chance of success if there are no facts pleaded, and therefore will avoid making a serious ruling that could impact many rights of many people in the absence of a good factual background to that. But I will hear you on the merits of your motion.
Thank you very much, Your Honor. If you want to proceed on that basis that in the absence of a factual matrix, that the matter should not be proceeded on, we would be perfectly happy with any decision you make on that basis. Beyond that, I think that my written representations set out the Attorney General's position fairly clearly, that there can be no duties rooted in the Royal Proclamation of 1763, in that the courts have determined that insofar as they are applicable to southwestern Ontario, that proclamation has been repealed by the effect of the Quebec Act. The case law is very clear and very authoritative, up to a refusal to reconsider the decision in Chippewas of Sarnia, refusal to reconsider granting leave to appeal the Ontario Court of Appeals decision in Chippewas of Sarnia. The second point, and this one again has been the subject of some exchanges between the plaintiff and Canada, there is absolutely nothing in the materials filed that suggests that an order in council was passed with the powers to determine any Crown Nation issues other than a very specific issue in Connecticut in 1704. I've put in my representations a transcription of virtually the entirety of the only thing that could be the order in council, and you'll see that it's very specific and very direct.
Where are you referring to in your motion record?
In my memorandum of fact and law, in paragraph, my transcription starts at paragraph 30.
Okay, that's where I was. I just wanted to confirm I was in the right place.
So on that basis, and particularly as you've indicated, you might prefer to address this on the basis of the absence of an evidentiary record. Unless Your Honor has questions, that's the essence, that the case law says those provisions of the Royal Proclamation aren't applicable to any Indian interest created in 1784. The chronology is very important. You have the Royal Proclamation in 1763. You have the Quebec Act of 1774, which repeals it. It's true that the Quebec Act doesn't interfere with any established interests as of the date of 1774, but on the basis of the plaintiff's pleadings, which we're acknowledging only for the purposes of the motion, the Indian interest he's asserting wasn't created until 1784. That is, say, 10 years after the Quebec Act. So, unless Your Honor has questions, I think that on the merits as well as on the evidentiary basis, it's plain and obvious that this action can't succeed.
Okay, thank you. Thank you for that, and thank you for that little chronology. It's not often I get to go back to the 1700s to look at a file, and I thank you and the plaintiff in this case for exposing me to some very interesting history. I'll turn to the plaintiff now for your reply to that.
Well, like I've asked in my claim in paragraph 1, I would like a declaration of what is the legal duty, in quotes, or the trust within the meaning of in Re-Indian Claims 1896 and Section 109 of the Constitution Act 1867.
Now, but let me just ask you, what has happened that raises this as an issue, or is this just an academic discussion? Have your rights as you want them in the Declaration been offended in some specific way?
Absolutely, yes. I took on the role to be the eyes and the ears of the Mohawk up here in the land we call Kanekota, which in our language means where the waters come from the earth. And I took that position over 10 years ago because of the Royal Proclamation of 1784, which was signed by a Captain General. That makes it a Royal Proclamation. And he said that the British Army would protect this land for us and our posterity forever. Now that's an order still standing. And I've talked with the General's office a few times. And, because I didn't know which other way to go, because I've been totally ignored since I got here. No one wants to deal with this issue. And so that's why I took this action of, I've been going through it for 10 years. And, I've experienced a lot of things up here, living up here in Kanekota, trying to spread the great peace. That's all I'm supposed to do as a Gunyangihanga. Mohawk, if you will. And so anyways, I've been having nothing but blocks at the municipal, at the provincial, at the federal level. It's just total ignoring and and I've experienced racism at its worst that I've seen in Canada. I grew up, born and raised in Toronto, and so, I mean, this is all, like, eye-opening for me. So anyways, that's why I really need to have this whole law thing. And, I've been put on a terrorist list with the police, and I've had secret police following me, and they've identified themselves. And I told them, I'm the only one here who is following the law in Kanekota. Everyone else is not. I mean, that's been my position. I've been treated as a terrorist. I mean, I'm the only one following the law. This is my position. And really, no one has dealt with Section 109 of the Constitution Act, and so we need to deal with that. That's basically my whole claim,
Have you sought legal assistance?
Well,
I don't mean in a formal monetary sense, but have you been consulting with lawyers on this?
I have a few people who have been helping me with legal backgrounds and historical constitutional experts. Yes, I have a good support system that has garnered around me, I guess. So yes, I have a bit of help with that.
But in particular, with helping you bring this forward as an action, I don't know if you fully understood my questions to the defendant's lawyer, but it's basically that we have a statement of claim here that seeks a declaration, but my problem is that you do not plead any facts, any situation that could give rise to these rights. You're just seeking in the abstract a declaration, and my question is whether you asked any lawyers for help in bringing this action to the court, and on what basis actions generally are allowed in the federal court.
Well, I really wanted to bring the constitutional question to the court so that it could be answered once and for all, since it's, I don't see anyone in any of the Book of Authorities of the defendant, I don't see anything on Section 109, and, this is the most important section for me. I've been just trying to follow the law, Your Honor, and
I know.
And now I have grandchildren. When I started, my children were still children, and does this go on forever? I'd like to solve this now, like before for my grandchildren now. I mean, I started up here. I did have another action that got thrown out by the Attorney General. That was 1396-12, and I'd been asking for all kinds of things, and so then from that I learned that I just need this one question answered. So that's the idea of this action. I just want to have that all answered. How do we interpret that as it applies to my situation here?
No, I understand why you're bringing it, or why you want clarity, but the problem is, or maybe when I look at it, that this is not the right vehicle to do so, or at least what you have formulated for us in your statement of claim may not be adequate to actually commence an action per se, which has a very legal and technical set of rules applicable to it, starting with that you must plead facts that raise the allegations against the defendant, and I'm not sure that you have in this case. You clearly said, I want this declaration that I have these rights. That's clear, but is that a proper action? That is the question that I'm asking.
Well, I'm saying I only want the prima facie identity of the proper law of this territory and the corresponding trust relationship. I think that's, addressing what I'm asking for. I mean, it's a question of constitutional jurisdictional law. There's many precedents that backs that. So, that's why I asked for it in writing. We could just do it all in writing, and then, I don't know. I don't want to go over all the writing. I rely on what I put in already as writing. But I mean, I guess, you know, I am asking for the prima facie identity of the proper law of this territory that I'm on, and the corresponding trust relationship between the settlers and us. You know, I mean, that I think I am asking for something, you know, based on facts right there.
Thank you very much, and I certainly will review your written submissions again to see what I can find. Mr. McCullough, we're back to you for any final words.
Your Honor, first of all, I have the citation.
Good.
From Kitkatma. It's paragraph 46. I'll give you the text. Constitutional questions should not be discussed in a factual vacuum. Even in a division of powers case, rights must be asserted and their factual underpinnings demonstrated. That's paragraph 46, and the style of cause is Kitkatma Band and British Columbia, 2002, 2 SCR 146.
Okay, thank you for that. I don't think that citation adds anything more to my concern. Thank you for your submissions today. I will reserve and have a decision to you. I hope not too long in the future. If this action does continue, I will recommend that a case management judge be appointed immediately. I know that there was a request that happen, and I know that request is being held in abeyance until this motion to strike was dealt with. But once I've decided, if I've decided to dismiss the application or the motion, then it will continue as case managed, and you will have a case management judge to deal with, which hopefully will help it move along if necessary. So thank you very much for your submissions this morning, and you've both made your positions very clear. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Court is concluded.
Thank you.